determined by the statute that governs the agency and the interpretation the agency has with regards to that statute. And that interpretation is entitled to deference. And unless clearly erroneous, it has to be supported.
Clarify me, counsel, what is it that you believe they can, that the insurance company that's seeking has made a rate filing, what is it they can present for consideration by the administrative law judge?
Well, clearly the testimony of experts. What usually has happened is what the agency...
Any testimony that was not presented to the agency?
No. Yes. What we're saying is that you can have, we're not sitting here saying that the agency, that is Division of Administrative Hearings, takes just the filing and just looks at it. It's entitled to an explanation of that filing. But what is actually happening is a new filing is being made at the Division of Administrative Hearings. New data, new theories as to how this now indicates that the rate is not excessive. We're not now dealing with an explanation of the filing.
Wait a minute. Do I understand that you're suggesting they can't present any new data?
That's correct.
Okay.
If you want to present
in other words,
data,
if the data they had presented to you was not sufficient to satisfy the agency that the rate was justified and you denied it, unless they got more information before you, you're saying they're stopped under the statute from presenting anything further?
That is correct. If you want to, if you are saying to us that you agree with us, okay, that the data we've given you was not sufficient to support filing, make a new rate filing. You're not harmed by going and making a new rate filing, presenting that information to us, because the legislature is clearly indicating.
Now, as I understand, the statute on the rate filing says that they determine what they think you need to have. You don't request information. That the insurance company determines what they think you need and presents it to you. And it's either sufficient or not sufficient.
That is correct.
And so if they guess wrong, you give them no guidance. You don't ask for information.
There's no guessing to this. We're talking about actuarial science and how this is going to be supported. They understand what they need to present in terms of what is needed to show that actuarially.
How do they understand it if they have the prerogative of deciding what is necessary and you determine that's not complete, not adequate?
First of all, this rule actually mandates that they file anything they want to have considered in support of the filing should be made in this rate filing. So what you're saying is that they don't have to comply with that. They don't have to provide everything they think needs, that they want to have considered in a rate filing. They can just file a sheet of paper that says, I want to charge this rate. I'm not going to give you any data. If you request that data, I'm not going to give it to you. You go to DOA, now all of a sudden that data is presented. The testimony and support for the rate they're now requesting is presented. Is this fictional? No. One of the cases cited by the appellee in this matter in support of their particular position was a case involving AIU over Division of Administrative Hearings.
Counsel, see, I think there was some information in the record, and maybe you can refresh my recollection. How many times a year are there challenges going to DOA on determinations for insurance company rates?
I do not have that data, but I'll tell you it's very few.
It seemed to me like in the record it was two or three times a year.
That may be absolutely correct, because the majority of the cases
doesn't sound like there's a whole lot of problem with submitting data to the agency under its normal review procedure.
I would agree with you. However, when it is a problem, it is represented by AIU, which set in place a use and file rate. That is to say, they began using the rate before they made the rate filing. That litigation went on for 2 years. It ultimately resulted in the refund of millions of dollars because, in fact, it was ultimately said that, well, even when they do finally present some evidence, in fact, the evidence doesn't support the particular position. Now, you may say, well, hey, they got a refund. Well, that sounds good unless you happen to be the person paying the bill. If you were the person who had to pay the bill.
I detect here, and I think I read in your brief, that one of the agency's real concerns is you want to get after these insurance companies who are trying to snooker you, and that they do it on a regular basis. They just don't submit information. And somehow, I call it kind of like the weasel effect. It just kind Does this record establish that as a pandemic problem within the industry?
I don't know that it needs to establish a pandemic.
And I'm
problem
wondering
in the
why
industry.
you have to have a rule for
But the
it.
answer to your question is, the reason you don't see as many filings as you do over there is because under subsection F, it allows us to ask for additional information. We spend a great deal of time having to request additional information to be provided to the office. What is problematic is when we ask for that information, it's not presented to the office, we go to DOA and it's presented there. How does that in any way enforce the regulatory scheme that the legislature set out, which is we're entitled to that information in the review process on which so that we may understand that rate filing? If you take the position that you don't have to give us the information we requested, and that happens, but you can then present it to a DOA judge, you've now undermined the very process that the legislature has put in place.
If it wasn't for the rule that the office had, this rule, would new evidence be allowed to be presented at DOA?
Well, first of all, any evidence you want to present to DOA that DOA wants to consider is up to DOA. We're not trying to regulate what DOA is going to take and define what they're going to have. What we're saying here is the basis of our agency action, based upon our reading of the statute, which we are in charge of administering. The basis of that action is the rate filing that is made with the office. If DOA wants to listen to other evidence, they're perfectly happy to do so. What we're saying is what they should be doing is listening to expert testimony with regards to the filing and what it shows, and resolving the differences of opinion between the insurer and the office with regards to whether or not it is in fact sufficient.
Well, I thought,
Justify the rate.
help me out here, I thought your problem really was that you wanted to eliminate some type of moving target, that you wanted the insurance companies to present what they wanted to present, whatever they felt was appropriate and necessary to submit in proof of their rate filing, and let the department make some kind of agency action on that and let that be it, and not have some kind of moving target then go to DOA.
That is absolutely correct.
Okay. Well, except for this rule, isn't the state of the law under Chapter 120, and it is interpreted by the Florida Supreme Court, that in fact it is kind of a moving target and additional evidence can be presented at DOA? And that's why you had the rule.
I kind of disagree with that. You're doing the same thing that DOA wants to do, which says that de novo means the same thing in every case. You don't look to what the agency is charged with doing. This rule is just a statement of fact that has been the basis of agency action of the office all along, which is the rate filing and the information that you filed with us. It is contrary to the scheme that the legislature has put into place to suggest that you can make a rate filing initially with the Department of Administrative Hearings. But that's what you allow when you sit there and say that information that is material to an understanding or to support this filing is first made with DOA. That's not what the legislature intended.
Well, what I'm trying to understand, and I guess I'm not communicating very well, is what difference does this rule make? What change does this rule have over what was going on before?
I think what it is doing is putting everybody on notice as to what we are going to be doing.
Which is what? What are you going to be doing differently?
What we are going to be doing is reviewing the rate filing. We're going to be asking for what information we think we need to understand that rate filing, and we're going to be making our ultimate decision based upon the information that you have provided to us prior to our agency action, which you now seek to have reviewed. We are not suggesting that the court or DOA is out there to review what we did. They're going to be looking at the rate filing initially from its own point of view. Whatever we did before is really irrelevant.
So are you going to ignore anything that comes, any new evidence that comes in through DOA?
Well, it depends on what the evidence is. I mean, if it's testimony by an actuary that explains fully what the filing actually shows, the answer to that question is no. If you are now going to change the theory by which you are raising your support for this rate increase, and you're going to introduce data that has never been reviewed by the office, then the answer may be yes.
Was that different up till this rule? I mean, would the department have accepted that new information but for this rule?
No, sir. In fact, I will tell you that at least on 2 occasions since I have been with the office, when that information came back to us, we did not accept that. We judged the filing based upon the filing. We actually had a judge who's decided at DOA that they have the right to set a rate, and that the recommended order came back to us saying, you will issue an order setting this rate, a rate different than what was asked for in the first instance.
So as far as you're concerned, the rule has made no difference whatsoever in the state of the law under Chapter 120?
I think the rule is a statement of what the law is with regards to 627.062. And no, it does not affect what 120 is. De novo is a concept, and it is a concept that it does not determine the scope of what the review or the evidence is going to be. That is determined by what it is ultimately has to be decided in that proceeding. And that's what this rule does. But you know what? We get ahead of ourselves because I have a real concern about whether or not we even have standing such that we should be here. The only fact of standing that was found by the ALJ was that this rule regulates a substantial number of the appellee's members. In point of fact, NAACP, which is a Supreme Court case we cited in our brief, says you have to show that you're substantially affected. And in that case, it once again does not say that mere regulation is going to be sufficient. It in fact sets out a basis upon which the injury in fact was demonstrated. And no injury in fact has actually been demonstrated by the appellees in this matter with regards to the application of this rule.
Mr. Parton, your argument sounds a lot like the majority opinion from this court that I was on the panel from. We got reversed by the Florida Supreme Court. I don't see how, even though I may agree with you, I don't think the Florida Supreme Court agrees with your position.
Well, I thought it did. The case that you set on, you found that in fact there was no substantial injury. And the Supreme Court said, well, sure there is, if you talk about NAACP.
Right.
They said there is. In fact, they quoted the dissenting opinion of Judge Browning, who set out quite eloquently what the injury was. But instead, you relied on coalition. And coalition said that all you got to show is that you regulate, you don't have to show anything else. And I suggest that the validity of that case is in question in light of the decision in the NAACP. And if you took the explanation of coalition in the NAACP case that was decided before this court, and you applied it to the issues that are presently here with regards to this appellee, I would suggest you would in that case, when you applied that explanation that is contained in NAACP, you would still find that there was no standing for any action.
Let me get you, I know you don't want to necessarily get
sir,
back on that issue, but I want to take you back to the other issue on the merits of this thing. When an administrative law judge, before this rule came up, what was their role in looking at the case?
Well, our view is we have, frankly, amply argued on more than one occasion to the division, was to take and review the filing in light of the testimony that was going to explain what that filing demonstrated. And the question would then be, if there is, and typically that's what it is a disagreement among the actuaries, the professionals, the role of DOA would be to resolve that, issue.
Now, you seem to argue that the role of DOA somehow changes or is somehow different, but for this rule. When you have this additional presentation or you're talking about the new evidence that comes in, how has the role of DOA changed any in reviewing that material?
It hasn't. It would come in by virtue of a new rate filing, and if in fact we found that it was not adequate, they would be reviewing that as well.
So the role of DOA really has not changed?
The role of DOA is not affected by this rule. This rule is a statement of what 627.062 requires of the office and the basis of agency action.
Now, you're well into your sum-up time, and I hesitate to ask, and if you want to wait till you rebuttal, but I mean, somebody drew an analogy to the bid cases, and that's apt, don't you think?
Yes.
That after you submit your bid, you can't change it, but still there's going to be, or maybe, and eventually an administrative hearing at which new information.
That is correct. Ultimately, there will be.
Comes in, and the agency is obliged to deal with the information provided subsequent to the preparation of the bid.
Certainly. What we're saying here, though, is make a new rate file.
But in the bidding context, they don't say, okay, make another bid. They say, all right, we'll go with this bid, but in the hearing, we're going to hear from experts who were in no way involved with the preparation or the case in any way. We're going to have all kinds of new information.
Well, you're going to have opinions, but in fact, the information contained in the bid cannot be changed. You know, you can't go back and say, okay, I want to fix this that I didn't comply with in this bid once that bid is open. And that's kind of where we are on this thing. You have the right to present whatever evidence you wanted to us. You gave us what you said was what you needed. You gave us what we then asked for, or at least we hope you gave us that. Sometimes you don't. But you're stuck with your decision with regards to this particular matter. If I could, I only have 2 minutes left. I'd like to reserve the rest. Thank you.
May it please the Court, my name is Cynthia Tunnicliffe, and I'm here representing the Florida Insurance Council. This rate filing before OIR, or a rate filing before OIR, is no different than any other application for government approval submitted to a myriad of state agencies. The applicant files an application on the form that is approved by the agency. The agency then has the opportunity to request additional information. Now, OIR is not required to file a notice of deficiency, but sometimes it does. And then...
Well, it's a little different, right? Can't they file and then immediately put into effect a higher rate?
Sometimes they can, sometimes they don't. There's two kinds of filings. You can file a use and file or a file and use. A file and use, you file for the rate, and it does not, you cannot put it into place until it is approved. Some insurance companies take the risk of filing a use and file, put the rates into effect, and then make their filing. So it's both ways. And I would say on a file and use that a company would not want to, they would want their rates approved as soon as possible so they could put them into effect. They're not going to just wait around until an administrative hearing to present their evidence. I mean, that's not logical to me. But anyway, the agency makes its decision. It's a preliminary decision. It's identified as a notice of intent to disapprove or a notice of intent to deny if it's another agency. This is preliminary agency action. And it is, the applicant then can request a 12057 hearing, and that is the formulation of agency action. It is the extension of agency action. It's not some foreign body over here that's making decisions. It's making decisions based upon all the facts before it, so that the agency, in its final determination, comes up with a better decision, a decision that's based upon all the facts. The agency, and that is a de novo hearing. It is a de novo. It presents all the evidence that you have to support your application or your rate filing. Appellant cites other uses of the term de novo, such as a de novo standard of review on appeal, and there are other definitions of de novo, but not in the context of the APA. The APA evidentiary hearing under 12057.1 is a full evidentiary hearing at which you can present all the evidence that you have to support your application. The rating law, the law that 627 provides that the notice of intent to disapprove is agency action for the purposes of the APA. And moreover, the rating laws provides that in the administrative hearing, not before OIR, but in the administrative hearing, this is in 627.062, the insurer has the burden of proof by a preponderance of the evidence to show that the rate is not excessive, inadequate, or unfairly discriminatory. There's nothing in the rating law to support the proposed rule which provides that the scope of the DOA proceeding in a rate case is a determination as to whether OIR's decision was correct. The administrative law judge found that the proposed rule, as a finding of fact, the proposed rule, based upon competent substantial evidence which has not been contested here, that the proposed rule does not simply define the contents of a rate filing, but operates to exclude all evidence offered by the insurer in an administrative hearing on insurance rates that was not previously provided to OIR prior to its notice of intent. So, because the only way to interpret this rule is that when final agency action is taken by the OIR on the recommended order from the administrative law judge, it will exclude all of that evidence that wasn't presented to it and make its decision only on the evidence that was presented to OIR. So I don't see any way you can interpret this rule other than saying that it's going to exclude new evidence that was presented to the administrative law judge. In addition, the APA itself provides that the 57-1 hearing is de novo. And this is specifically recognized in the rating law itself. The rating law, 627, that's supposed to be the support for this rule, specifically says at 0612 that in any proceeding to determine whether rates governed by this part comply with the law, the court shall set aside, the appellate court, this court, shall set aside a final order of the office if the office has violated 12057-1K, which is de novo review under the Administrative Proceeding Act, by substituting its findings of fact for findings of an administrative law judge, which were supported by competent substantial evidence. So the rating law, the 627 law itself, does not allow OIR to do what it's trying to do under this rule. It's not only contrary to the APA and the rating law, but to all of the case law interpreting the APA from the beginning of time. This court in McDonald in 1977, and again in DOT versus JWC in 1981, all said that the 12057 hearing is the formulation of agency action, not review of action taken preliminarily before that.
So in the analogy I used earlier, the term, I said a moving target, and it is a moving target, but by design, it's preliminary agency action, and because it's not final, it is a moving target. Is that right?
It's not, I wouldn't say it was it is a moving target, but they have the same rights to discovery and depositions and whatever to determine what the applicant's going to present at hearing as the applicant has is what OIR is going to present.
So is the effect of this rule really to try to convert what is preliminary agency action to final agency action subject to some kind of review that's not been done before by DOA? Is that what's going on?
I think that's one way to say it. I think what it does, in effect, is it discounts anything that is presented at DOA that was not presented to OIR. That's what it says. I mean, that's the language, that the basis of final agency action, specifically, the sole basis for final agency action shall be what was submitted to OIR.
Now, in a file and use scenario, there's an original rate filing. They may solicit additional information and may do that more than once. So they permit themselves, so eventually whatever has accreted becomes the filing. And there's really no issue because if the rate's not in effect, there's no great problem with that. There being some lack of clarity about the date when the filing was made. But they're saying they want that cut off before you get to an administrative hearing. That's their position.
Okay.
That's not. Is that? Do I understand correctly?
No, I think what they. And another thing to bear in mind, though, is that they're not required to ask for additional information, and sometimes they don't. And many times, the notice of intent to disapprove has new information, a basis for denial which was not previously known to the applicant. Now, if there was a mandatory requirement that you ask for additional information, and that if that's supplied, then it's basis. But that's not the case here. The notice of intent to disapprove can raise issues which were not known to the applicant as being grounds for disapproval. So where else will the applicant respond to that new issue, if not at DOA? But apparently, that is not, if it wasn't presented to OIR, when the applicant didn't know that it needed to present it until the notice of intent to disapprove, then they have that information, new information has to be presented to DOA, and that's what's contemplated by the APA. You get a notice of intent.
Counsel, you sound like that perhaps the agency is treating the insurance company as terribly as the insurance company treats the agency. In their brief, they did argue that insurance companies try to snooker them all the time, and that's one thing that bothers them. Are you suggesting that maybe the agency is doing that in return? And I'm wondering if that is even a consideration that we ought to involve ourselves with in determining the appropriateness of a rule.
And I would not suggest that you do that, Your Honor. I'm just suggesting that that if you look at the practicality of it, if you don't know the basis for the denial until the notice of intent to disapprove, how would you present that information to the agency prior to the notice of intent to disapprove? The only place to present that is at DOLA. And one of the basis of the rule was that, and testimony from Mr. Parton, by the way, who was testified at the administrative hearing, was that they were getting snookered. These people were coming in and not presenting all their evidence to OIR.
And you say you can't really imagine anybody would do that intentionally because it just delays when they'll be able to collect additional monies from their insurers.
It's illogical to me, and in my experience, I think that's illogical. I mean, that's just not done. Every insurance company that I've represented wants that decision as soon as possible. It's less money. If it's a use and file, it's less money they have to refund. They'd rather know that sooner. If it's a file and use, they want to put their rates into effect. They want a favorable decision from the agency first because that's the quickest way to get it.
So you can't imagine any tactical advantage in delaying intentionally until the 12057 hearing in order to present the information in support.
No, Your Honor, I cannot. And actually, the administrative law judge rejected that as a basis. I mean, she found the rule to be arbitrary and capricious, not based on fact and logic. And I think that the facts that they presented at the administrative hearing was the fact that people were withholding information from them.
Well, what about in a use and file situation? That would permit them to continue to collect the increased rate until the administrative hearing, or even then there's no tactical advantage?
Well, because then they have to refund it. If they are not successful, they have to refund it. So I don't think that's a particularly welcome event. I think that if you look at all of the case law under the APA, that there is a definitely the ability to present new evidence at the administrative hearings stage. The Florida Supreme Court in Young versus Department of Community Affairs, Florida Supreme Court decision, said that by stating that the hearing should be held pursuant to Chapter 120, the legislature also has indicated that the hearing should encompass more than just the record below. Specifically, new evidence can be presented. And of course, this court in Hamilton County, which was cited by the administrative law judge, specifically said the same thing. Because the hearing is de novo and because the proceeding is intended to formulate final agency action and not to review action taken earlier and preliminary, the hearing officer may consider changes or other circumstances external to the application. So,
all right, so you're not advocating that an ability, that you should have the ability to change the application willy-nilly. You are saying that as in a bid case, maybe the application sets some parameters, but a rule that would prohibit any information provided subsequent to the office's issuance of a notice of intent will interfere with the APA process as heretofore happened.
I do think it's different than the bid cases. I will say that the application is the application. I mean, you're not, I mean, in any of these proceedings, you've made your application and it is what it is. But having said that, I mean, the bid cases are different because what they're saying there is that at the time, it's a competitive process. It is not an applicant for a license, an individual license. The bid protest is a competitive process, much like CON, where you can't go back in and change the bid that you submitted at the time that you submitted your bid because it would be a competitive disadvantage to allow you to come forward later and supplement information for which you were found deficient and another person awarded the bid. And I think this is clearly made in Vision Care, which is an administrative law case, I understand, Vision Care versus School Board of Broward County. But the administrative law judge there said, quotes from McDonald in the formulation of agency action, and the 12057 hearing commences de novo proceedings. And then says, however, a bid case differs in many respects from the conventional regulatory proceeding, and certain constraints must necessarily apply as to the type of evidence that may be presented by a party. That is, the events surrounding the bid decision are frozen in time, and a party cannot present evidence at final hearing to cure deficiencies that were present when the bids were initially submitted. And I think the bid cases are different for that reason. You can't, you know, if you've got 5 people making a bid and the agency says, okay, on that day they opened the bids and one of them is deficient, you can't, and clearly it is, you can't go back at the administrative hearing and supply that deficiency so that you can leap over the person to whom it was awarded.
Well, you
can't
can't alter the bid, but you may be able to call an expert that says this specification is met for the following reasons.
Yes, yes, and yes, that's exactly right. It's not really a deficiency for these following reasons in the bid. I think that's right. But these, where you have a licensing application and a 12057-1, and bids are heard under 12057-3, which has a different procedure. But 12057-1, if you have the de novo hearing, you can come back in and provide all the information that is necessary to get your application granted. And that's been the law since the APA was enunciated, since McDonald. People come in at their administrative hearing and present all the evidence that's necessary to support their application. And I do think we have standing, the Florida Insurance Council has standing, the administrative law judge made a determination as a finding of fact that we met the requirements of NAACP. That fact was not disputed at the administrative hearing. The basis, the factual basis, was not disputed here as competent substantial evidence. And I do think that
You're not saying there was a stipulation, but...
No, but it was not. They presented no contrary proof.
But now you are talking about only 2 or 3 cases a year where this arises.
You mean in the rate cases?
Where it even gets to DOA.
I don't know the answer to that, Your Honor. I don't know how many go to DOA. It doesn't appear to me from what I see that many go to DOA. But I mean, under NAACP, the Florida Insurance Council has standing, and I think, Judge Polston, that they specifically in that case rejected the requirement that an association must show injury in fact, and I think what they are alleging here is that Florida Insurance Council has to show injury in fact, and I think that was specifically rejected in NAACP. And for all those reasons, we believe that and would request that the administrative law judge's final order be affirmed. Thank you.
Very briefly, first of all, we're not saying that FIC has to show that they have an injury in fact, but we do say that they must demonstrate that their members in fact have an injury in fact, and I disagree with the interpretation that NAACP has relieved them of that responsibility. But that's a legal issue that you all will have to ultimately resolve. I think it's very important. We filed a notice of intent to rely yesterday on the latest legislation that was put forth in the last special session. And frankly, I think it provides even more force to the argument that, in fact, the rate filing is the basis upon which a decision is going to be made. I sense that the court thinks that what we have tried to do here, I assure you that isn't, and if we need to draw this rule more narrowly, then of course we can, that we don't have to consider the testimony that is presented in a rate filing. For instance, as in a bid case where an expert is explaining what, in fact, this filing actually shows. Quite to the contrary, I think we do. I think the resolution of that dispute, that factual issue, whether or not the rate filing supports or is not supportive of the rate that is being asked, is frankly what they're supposed to be determining out there. So if we've overdrawn this, drawn it too broadly, if you will, fine, we can fix that. But the notion that something other than rate filing and testimony about that rate filing is to be considered by DOE, I disagree, and that is made very clear, at least in my opinion, with regards to new legislation. There's been a new section added to 627.
Well, of course, that was not in effect at the time of the rule challenge hearing.
No, but it will be in effect when the rule becomes effective. And in fact, it is further indication of what we have said all along, which the legislature wants this decision based upon.
Has that been enacted, or is that just...
Yes, it has. It's been cited in the law. And subsection 9A on page 48 of the Florida laws of 20071. And it says the following: effective March 1st, 2007, the chief executive officer, chief financial officer of the property insurer, and chief actuary of the property insurer must certify under oath and subject to the penalty of perjury on a form approved by the commission the following information that must accompany a rate filing. Based on in subsection 2, based on the signing officer's actuary's knowledge, the rate filing does not contain any untrue statement of a material fact or omit to state a material fact necessary in order to make the statements made in light of the circumstances in which the statements were made not misleading. Subsection 3, based on the signing officer and actuary's knowledge and information and other factors described in 627-0622B, including but not limited to investment income, fairly present in all material respects the basis of the rate filing for the periods presented in the filing. This is another statement by the legislature that it is the rate filing and the information that is presented to the office which is the debate before the Division of Administrative Hearings, not some new filing that is then made subsequently at the division. In order for this to be an orderly, efficient process that protects the public from excessive or inadequate or unfairly discriminatory rates, this is, and what we are talking about here, the best way to go. To hit a moving target in the context of a rate filing, where we all have acknowledged, and the courts have significantly acknowledged, that it is a crucial, very technical aspect that has to be reviewed. That in fact the experts are over here at the office, not at DOA, not in the courts. To allow rate filings to first be made with DOA.
Counsel, let me ask you a question. I read this last night after it came in, and I'm reading it again. I'm listening to you, and I want to know, how does this change the role of the administrative law judge under 120? All this does is require the insurance companies to make certain representations under oath and swear that they've done everything that they can do properly, which may, if it turns out that that is false, may impose certain sanctions. How does this change the hearing mechanism if they are in disagreement with the agency over whether or not they've justified their rate?
Judge Barfield, the role of DOA depends upon what it is that the agency and the actions the agency is supposed to take in the basis of that. It doesn't change it. It further enforces or reinforces the notion that I have put forward to this court, that in fact the agency and the basis of its final agency action is based upon the rate filing. When it goes to DOA, DOA is to determine whether or not that rate filing in fact is supported or not supported. It doesn't change anything. It really reinforces what I have been saying here. The legislature considers the rate filing and the information provided to us must be complete. You must not leave out any material matters that you are to be considering. How does that impact DOA? It impacts DOA in the sense of it has to look at what the basis of our administrative action is and what the intent of the legislature was in the rate review process. De novo is to be defined in the context of the action that has to be taken by the agency. It is not a constant.
Okay, you've got a filing. You've got a notice of intent to disapprove. So doesn't that join the issue? And isn't that what is the proper subject of an administrative hearing?
Well, first of all, the notice of intent doesn't even have to give a reason for its denial. It's irrelevant. If you're having a de novo review of a rate filing, okay, or even of the rate, whatever we decide in a notice of intent is irrelevant. because this is a new proceeding. Whatever we decided, whatever the basis was, who cares? The question that the DOA judge has is, does this rate filing support the rate requested? Does the testimony, the expert testimony that was presented to it, demonstrate that, in fact, that rate filing contains the information necessary to support the fact that the rate is neither excessive, inaccurate, or fairly distributed?
I don't hear anybody arguing otherwise.
Well, what you do here is, now, we can now, for instance, change the theory of the rate filing. We have a certain risk rate that is in the rate filings for the office. We can now go over there and change that risk factor. We provided certain information, and the data did not show what we wanted. Oh, okay, we'll change that data and file new data over here that's never been reviewed by the office. The bottom line is, what you're encouraging is the making of a rate filing before DOA, not before the office. The legislature intended for us to have the opportunity to review the information that is supposedly supporting the filing first, not at the time it goes to DOA. First. And thus we can refine the issue of what the DOA judge is supposed to determine. DOA judges do not have the expertise to deal with this. Judges don't have expertise to deal with this. If you define what, in fact, it is we're supposed to be deciding over there, it not only helps us. We don't have to hit a moving target. Our actuaries don't have to look at information they haven't seen before and make opinions, but the DOA judge as well.
But now, on hitting the moving target, we were just told that the burden is on the insurance company. So any sort of question about where the target is, I would assume, be of more concern for the burdened party.
No, I don't think so. The advantage, by the way, of going to DOA is because the expertise isn't necessarily there. And we're not going to be able to necessarily know exactly what the testimony is going to be in support of the filing. How do our experts address new information?
You can't depose these people? You don't have discovery?
It's just interesting. I'll give you an example of what happened. Sure, we can depose them. Today, the expert knows nothing. He gets up on the witness stand on the day of trial, and suddenly he is the most brilliant man I have ever heard. On the same questions that were asked from him in depot. Yes, we can impeach him. So what?
Well, this sounds like a generalized hostility to the DOA hearing
No,
process.
not at all. Not at all. I'm just telling you what the reality is. The legislature didn't intend for us to determine a rate based on discovery. It's based on the information that is required to be filed with us. And no, I don't have any. I'm sorry. If that sounded like that, Judge Benton, I apologize. DOA has a tough job out there, and they're just like us. They're up there. They're busy.
Oh, we pick on him, too, because he used to be a DOA hearing officer, but that's all right. Let me ask you this.
I'll stand on my pick on him.
I'm trying to find out what it is that you targeted, because, frankly, I'm having difficulty understanding that. And are you suggesting, for example, that if in the filing before your agency, data is presented that says, we have experience, and this is the incidence of a certain type of occurrence, as how many times it's going to happen in the state of Florida, and it turns out that data is wrong, that their experience factor is different, and you don't want them to present new information to DOA on it. I'm trying to.
What typically happens?
In other words, what any actuary that you would say, no, this information you provide doesn't justify the rate. Even if they say, oops, well, we'll change it because we have new experiences.
Yeah. Disputes that come with regards to data are, number one, does it actually demonstrate what is being done? Number one. Number two, how the insurance company may have manipulated that data in support of it. And when I say manipulate, that's not a pejorative term, okay? Actuaries do manipulate data. They use certain smoothing techniques. If you have a bad experience 1 year and a good
You have to be able to tell the truth 3 different ways before you tell the lies.
Well, there are ways to manipulate the data, and the question would be whether or not the data that you have provided, even if it's manipulated by you, justifies, in fact, what you're doing. We're not saying necessarily the data is wrong. The question is whether the data is sufficient to do that. And so we say, no, it's not. All of a sudden say, well, wait a minute, we've got some new data that we want to present. Well,
Okay,
Where's the
now,
harm?
is this the point at which you don't want them to present new data?
Now,
to-
they can present new data in the form of a new rate filing.
That's what I'm saying. They can't appeal your decision and present that new data in, when I say appeal, they can't seek the 12057 hearing and present that new data on this previous filing.
I'm saying that that is not the legislative intent. If we have asked for that information, and by the way, many times we do, if we've asked for that information, you present it, it becomes part of the filing. If you present that information before we take the agency action that ultimately triggers your right to 120, certainly we're going to review it. If it is past that time, there has to be a point of finality where, if you want to do that, make a new rate filing. Because you now have changed what you're going to do. And there's no harm in doing that.
But now, you don't have a problem with all these changes as long as they're filing with you.
That's because our experts can sit down and evaluate the information that is going to be used to support that filing in a calm, correct way of doing it, as opposed to in the middle of trial dealing with information that ultimately is presented literally all too often directly from the stand. Because then the actuaries are asked, well, what do you think of this? Well, I just got it. This is one of these things that we normally would have to take a week or two to be able to evaluate and manipulate it in order to answer that question. Now I'm being asked to do it today. That is not the way rates should be reviewed.
Well, I'm not in a position to disagree with you about that, but it seems like if some other procedure is needed, you need a statutory exemption from the APA, stuck in 120.80 somewhere.
Judge, if that's the way you feel, then I guess we lose this particular issue. However, I think de novo is undefined. It is undefined by the State Board of Administration, which is given authority to create rules for the Division of Administrative Hearings. De novo is a concept that, as pointed out, applies depending on the context in which it is used, in an appeal, in a review of a bid protest. Interestingly, I agree with what Councilor Apperly says. This is nothing more than the type of application you might have, for instance, in a licensing case. But you know what? In a licensing case, DOA allows you to say license is insufficient. You don't get to correct that in the middle of a DOA hearing. If you're going to deny that, you can deny it on the basis that it's insufficient. What you're saying to us is that we cannot deny something on the basis of insufficiency. By the way, there may be only 2 or 3 rate filings that are made a year at this point. The legislature and the legislation I've given you has done away with the rights of arbitration. Most of the cases that have been protested with regards to rate filings have been in arbitration. In the last year alone, we've had somewhere between 7 and 10 arbitrations that were filed. Those matters will now be going to DOA.
Thank you, Councilman. Next case on our calendar is